All right. Future property titans of Singapore, you've got your sights set on that RES exam, the gateway to your real estate empire. Smart move.
Absolutely. It's a big step.
But let's be honest, knowing the square footage of every Sentosa Cove bungalow isn't going to cut it. There's a legal jungle out there, you
Oh,
know?
definitely. It's crucial.
And today, on Ace Your RDS exam, we're grabbing our machetes, metaphorically speaking, and hacking our way through a really vital concept, negligence. Think of this as your secret weapon, yeah? The knowledge that'll keep you out of trouble and, crucially, help you nail those tricky exam questions.
Welcome, everyone. Our goal today is laser-focused, to give you a clear, concise understanding of negligence as it directly relates to your career as a real estate salesperson in Singapore.
Exactly.
We'll be extracting the key principles from the source material. Notes, CU2.4 negligence, basically translating that legal speak into plain English.
Good.
And highlighting what you absolutely need to know to, well, ace that exam and thrive in your practice later on.
Yeah. Exactly. We're on a mission to make negligence not just understandable, but almost, dare I say, fun.
Well, maybe not fun.
Okay, maybe not fun, but definitely not something that'll make your eyes glaze over. We want you to leave this session feeling confident, ready to tackle any negligence-related questions the examiners throw your way.
That's the aim.
Now, before we dive into the deep end, let's quickly touch on a foundational idea, the tort.
Yes. Tort.
It sounds like something you might find in a fancy French bakery, doesn't it? But trust us, this one has legal teeth.
It really does. Legally speaking, a tort, from the old French for wrong, is an act, or sometimes a failure to act, that causes harm to another person.
Right.
And that leads to civil liability. Think of it as a legal boo-boo that can result in a lawsuit where the injured party seeks compensation.
Okay. Makes sense.
And for those of you heading into real estate, the most common type of tort you're likely to encounter, you guessed it, negligence.
Negligence. Okay, so let's get down to brass tacks. What exactly is this negligence we keep talking about? In everyday life, it's just being a bit clumsy, right? Like forgetting to switch off the iron. Hopefully not something you do when showing a client a property. But is legal negligence just about, butterfingers?
Not quite. While simple carelessness, plays a role, legal negligence is more defined.
Okay.
Our source material highlights that it covers both actions, actively doing something wrong, and omissions failing to do something you should have done.
Okay. Actions and omissions.
Yes. So it's not just about actively misrepresenting a property. It could also be about failing to disclose known defects, for example.
Right.
And here's a crucial point for your exam prep. As a real estate salesperson, you can be held negligent not only towards your clients, the ones who hired you,
Yeah, principal.
but also towards complete strangers, what the law calls third parties.
Wait a minute, hold on. Negligent towards people I don't even have a contract with. How does that work? I thought my main loyalty was to my client.
It's a common misunderstanding, actually. Consider this. If you provide misleading information about a property to a potential buyer, even if they're not your direct client, and they suffer financial loss because they relied on your inaccurate info, well, the law recognizes you have a responsibility to be truthful and careful with them, too.
Wow. Okay.
Proactively understanding this duty isn't just about avoiding lawsuits. It's about building that reputation for thoroughness and trust. That really sets you apart.
Okay, that makes a surprising amount of sense. So it's not just about being generally careful. There are specific boxes that need to be ticked for someone to successfully sue me for negligence. What are these? These essential ingredients.
Right. There are 4 key elements. Think of them as the 4 legs of a table. If one is missing, the whole thing falls over.
Okay, 4 legs. What are they?
First, there must be a duty of care.
Duty of care. Got it.
Second, there must be a breach of that duty.
Breach. Okay.
Third, the breach must have resulted in damage.
Damage. Makes sense.
And fourth, that loss or damage must not be too remote.
Not too remote. Okay, let's unpack those. Starting with duty of care. Sounds very official. What does it actually mean for someone like me trying to sell a condo?
Right. At its core, a duty of care is the legal obligation to exercise reasonable skill and care in your actions and omissions to avoid causing harm to your neighbor.
Neighbor, like the person next door.
Huh? No, not just the person who complains about your late-night karaoke. Neighbor, in this legal sense, is much broader. This comes from a foundational case, Donahue v. Stevenson, way back in 1932.
Ah, yes, the legendary tale of the ginger beer and the unwelcome snail.
That's the one.
For those who haven't heard this classic, picture this. A lady enjoys a refreshing ginger beer, only to discover a rather, decomposed snail lurking at the bottom. Ugh.
Exactly. And since her friend bought it, she couldn't sue the shop for breach of contract, so she went after the manufacturer for being negligent.
And the verdict.
The House of Lords, in a groundbreaking decision, sided with her. Lord Atkin laid down the neighbor principle. He stated, and this is a quote worth filing away for the exam,
Okay, listening.
"You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor."
Right. Reasonably foresee.
And he defined neighbor as persons who were so closely and directly affected by my act that I ought reasonably to have them in contemplation. Basically, anyone you should reasonably think about being affected when you act or fail to act.
So basically, it's about thinking ahead and considering who might be affected by what I do or don't do. It's like a real estate agent's version of look before you leap, but applied to potential legal headaches.
Precisely. And for you aspiring RES professionals, this neighbor principle is gold. It means you owe a duty of care not just to your principals, the folks who hired you.
My seller, for instance.
Exactly. But also to third parties, like potential buyers visiting an open house. If you misrepresent a crucial detail about the property, causing a buyer to make a costly mistake, you could be on the hook for breaching this duty of care.
Okay, duty of care, got it. Think about who I might affect. Now, on to the second ingredient. Breach of that duty. How do we know if someone has actually, dropped the ball legally?
Well, a breach of duty happens when the required standard of care isn't met. It's essentially failing to act as a reasonable man would in a similar situation.
The reasonable man. Who's this guy?
Yeah, it's not a specific person. It's a legal benchmark, an objective standard. It's about how an ordinary, prudent person would behave under those circumstances.
So if I accidentally knock over a vase at a viewing, that might be clumsy, but maybe not a legal breach.
Probably not. In most typical cases, no. But, and this is key, as a professional, a licensed real estate agent, you're held to a higher standard than the average reasonable man.
Ah, okay. Higher standard.
Yes. You're expected to possess the skill and expertise of a reasonably competent professional in your field. Think of the reasonable real estate salesperson, someone who knows the regulations, represents properties accurately, advises clients properly. It's like expecting a doctor to know more about medicine than, say, a taxi driver.
Makes sense.
You're expected to act with the competence of a reasonably skilled salesperson, knowing the laws, describing properties accurately, guiding clients with due diligence.
So a breach for an agent might be something like forgetting to mention a known major leak problem to a buyer.
Exactly. That would likely fall short of the standard of care expected of a reasonably competent real estate salesperson. That's a breach.
Okay. Breach of duty not meeting the professional standard. Now, ingredient number 3, resulting damage.
Yes. It's not enough to just show someone had a duty and they messed up. The person claiming negligence, the plaintiff, must also prove they actually suffered some demonstrable loss or damage.
Okay.
Because of that breach. Directly because of it.
So if I'm negligent, but luckily no one actually loses money or gets hurt, then there's no legal negligence claim.
Correct. Damage is critical. And to figure out if the damage was a direct result of the breach, the courts often use the but-for test.
The but-for test, how does that work?
It's pretty straightforward, actually. The question is, would the plaintiff have suffered the damage but for the defendant's negligence?
Okay. So if someone bought a property based on my negligent advice about, say, rental yield, and they wouldn't have bought it and suffered the loss but for my bad advice, then the test is satisfied.
Precisely. That establishes causation. However, sometimes life is complicated, right?
Yeah.
There might be multiple causes contributing to the damage.
Yeah, what then?
In those cases, the court will assess how much each factor contributed to the loss. It tries to apportion responsibility.
Okay, 3 down, 1 to go. Duty, breach, resulting damage. Now, this last one, loss or damage not too remote, sounds a bit abstract.
It deals with the legal concept of remoteness. Basically, the law says that even if your negligent act started a chain reaction, you shouldn't be responsible for consequences that were completely unpredictable or far-fetched at the time.
So there's a limit.
Yes. The damage claimed must have been reasonably foreseeable when the breach happened. This is the reasonable foreseeability test.
And there's another famous case for this, isn't there? Something involving a ship in oil?
Yes. The wagon mound? Oh, that one. Good memory. Oil was spilled from a ship into a harbor. Initially, it wasn't thought the oil could catch fire on water.
Right.
But later, due to some welding sparks from unrelated work nearby, something totally unforeseen in the oil did ignite and caused massive fire damage.
Okay.
The court ruled that while the oil spill itself was negligent, the fire damage wasn't reasonably foreseeable at the time of spill, so the claim for the fire damage failed. The damage was too remote.
So if an agent gives wrong zoning info and the buyer later faces huge costs because of totally unexpected government policy changes years later, the agent might argue that damage was too remote.
That's the kind of argument, yes.
Yeah.
It's about whether the type of damage was a foreseeable consequence of the negligence.
So it's not enough to just say, well, if A hadn't happened, then D wouldn't have happened, then C. There needs to be a reasonably direct, foreseeable link.
Exactly. And importantly, you don't need to foresee the exact way the damage occurs or its precise scale, just the general type of damage.
Okay. Like if I misrepresent balcony safety, I don't need to foresee a broken leg specifically, just that some physical injury is foreseeable if it collapses.
Precisely. You've got it. Foreseeability of the type of harm.
Right. The 4 horsemen of negligence are now clear: duty, breach, damage, remoteness. Now, our notes highlight something particularly relevant for us: negligent misstatement. How's that different from, general negligence?
Good question. While general negligence covers all sorts of careless actions and omissions, negligent misstatement focuses specifically on careless statements, spoken or written advice, information.
So words.
Exactly, words. Given that real estate agents are constantly providing information, giving advice, this is a really, really important area for you.
I can see that.
Especially in a fast market, there's pressure for quick answers. Knowing about negligent misstatement encourages that check before you speak habit. Very important.
So if I give some wrong info about, say, the potential for an MRT station nearby, even if I honestly thought it was true but I hadn't checked properly, could that be negligent misstatement?
Yes, that's exactly the kind of scenario. A negligent misstatement is basically a false statement of fact made honestly but carelessly.
Okay, carelessly.
Which someone else relies on, maybe enters a contract because of it, and then suffers financial loss as a result. Think inaccurate floor size, wrong info on zoning, potential en-bloc details.
Right, things people rely on heavily when buying property.
Absolutely. These misstatements can have huge financial consequences.
So it still needs those same 4 ingredients: duty, breach, damage, remoteness, but the breach part is specifically about saying something careless and wrong.
Exactly. The core negligence principles apply, but the focus is on the communication of incorrect information. For agents who trade in information, understanding this is vital. Vital for the exam, vital for your career.
Definitely. Okay, this is all starting to click. Now, what if someone does try to pin a negligence claim on me? Are there any defenses, ways to fight back legally? Our notes mention a few. Potential get-out-of-jail-free cards.
Yeah, well, maybe not quite get out of jail free, but yes, there are recognized defenses. 3 common ones you absolutely need to know for the RES exam are contributory negligence, illegality, and assumption of risk.
Okay, let's take them one by one. Contributory negligence. That's when the person suing me was also partly at fault, right? They contributed to their own problem.
Precisely. If the claimant the person suing was also negligent, and their own carelessness contributed to their injury or loss, the court can reduce the damages they receive.
To reflect their share of the blame.
Exactly. Our notes give the example of a factory worker burned by a faulty torch. But they weren't wearing their safety mask, which they were supposed to. Their failure to wear the mask contributed to the severity of the burns.
So, if a buyer relied on my negligent advice, but they also clearly failed to do some basic checks they should have done, their damages might be reduced.
That's the principle, yes. Singapore has the Contributory Negligence and Personal Injuries Act, which allows the court to apportion the damages based on each party's share of responsibility.
Okay, useful to know. What about the second one? Illegality. Sounds serious.
It is the defense of illegality, or ex tupi causa non oritur actio, if you want the Latin.
Whoa. Okay, maybe not.
It basically means a claim might fail if it arises directly from the claimant's own illegal or seriously immoral actions. It often comes up if both parties were involved in something dodgy together.
Like if I was, hypothetically, helping someone find a place specifically for an illegal activity, and then they tried to sue me for negligence related to that dodgy deal.
That's the sort of area it covers, yes. But courts are careful with this one. It's not automatic just because the claimant did something wrong.
Needs a strong link.
Yes, the illegal conduct needs to be sufficiently connected to the harm suffered, and the defendant's negligence shouldn't be sort of disproportionately worse than the claimant's wrongdoing.
Got it. Okay, final defense. Assumption of risk. Volenti non fit injuria. I remember that bit of Latin. To a willing person, injury is not done.
You remembered it, exactly. This applies if the claimant knowingly and voluntarily accepted the specific risk that caused their harm.
Knowingly and voluntarily, both important.
Absolutely critical. The claimant must have had actual knowledge of the specific risk, understood it, and freely chosen to accept it.
So if I warn a buyer, careful, that step is loose, and they say, yeah, I see it, but then trip on it anyway, maybe they assumed the risk.
That's the idea. The notes use the amusement park example. You get on a scary roller coaster, you accept the risk of being thrown around.
Right.
But if a bolt comes loose because the park was negligent in maintenance, that's not a risk you agreed to. It has to be acceptance of this specific risk that materialized.
Okay, these defenses are good to have in the back pocket mentally. Now, let's zoom right back into our world. Estate agency work in Singapore. The notes talk about the specific duty of care here.
Yes. As we mentioned, once you're appointed by a principal, your client, you immediately take on fiduciary duties.
Fiduciary, that means utmost good faith, right? Loyalty.
Exactly. Loyalty, obedience to lawful instructions, acting with care and skill, diligence. It's a high standard. Failing these duties can lead to breach of contract, negligence claims, or even fraud if it's really serious.
So it's way beyond just finding a buyer. It's about acting in their absolute best interest carefully and honestly.
100%. And remember what we said about third parties. Even without a contract with, say, a potential buyer looking at your seller's property, you still owe them a duty of honesty, reasonable care, and skill in what you tell them, and a duty not to misrepresent your authority. You can't just wing it or tell white lies to get the deal done.
Okay, honesty and care apply broadly. That's a key takeaway. Now, is there a specific rule book that defines the standard of care for Singapore agents?
There is indeed. The absolute benchmark is the Code of Ethics and Professional Client Care, the CEPCC.
CEPCC.
Okay, it's part of the Estate Agency Work Regulations 2010. You need to know this code. Think of it as your professional rule book.
My professional Bible, you said earlier. So what's in this CEPCC? What are the highlights for exam purposes?
Well, it covers a lot, but key areas include knowing and complying with all the laws, CEA circulars, guidelines, and knowing the essential facts about the properties you handle.
So ignorance is definitely not bliss.
Absolutely not. It also mandates proper due diligence, adhering to all legal requirements.
Okay, due diligence.
It outlines your general duty to clients and the public, prohibits conduct that could discredit the industry.
Right. Professionalism.
Specifies duties around signing documents, conveying offers accurately, providing interpretation if needed, ensuring advertisements are truthful.
Wow, it's pretty comprehensive. What else?
It covers avoiding conflicts of interest, very important. Recommending clients get independent legal or financial advice when appropriate.
Good point.
And, crucially, safeguarding confidential client information.
Okay. And not following this CEPCC. What happens?
Failing to observe the CEPCC isn't just bad practice. It can be deemed unsatisfactory professional conduct or even professional misconduct by the Council for Estate Agencies, the CEA.
And that means disciplinary action, fines, suspension.
Yes, potentially all of those. So knowing and following the CEPCC is fundamental to protecting your license and your reputation.
So mastering the CEPCC is not just exam fodder, it's survival. Okay, so if an agent does breach their duty of care, maybe by not following the CEPCC, what can the client do? What are the potential consequences?
Well, breaching the duty of care in negligence can lead to similar outcomes as breaching the actual contract with your client.
Like what?
Our notes list several possibilities. The principal might be able to rescind the contract, basically, cancel the deal.
Wow.
They might demand forfeiture of your commission, so no payday. They could sue you for damages to recover any financial losses they suffered because of your negligence.
Right. Lawsuits.
And, as we just mentioned, they could report you to the CEA for disciplinary action.
So negligence can really hit you from multiple angles, contractually, financially, professionally, through the CEA. Definitely need to take this seriously.
Absolutely. Understanding these concepts, the four elements, negligent misstatement, the defenses, and especially your duties under the CEPCC isn't just about passing the RES exam. It's about building a solid foundation for an ethical, successful, and hopefully long career in Singapore real estate.
Couldn't agree more. All right, soon-to-be RES certified superstars, let's quickly recap the key takeaways before we send you off to conquer that exam.
Here's the idea.
Remember those 4 non-negotiable ingredients for negligence. Duty of care, breach of that duty,
Right.
resulting damage directly linked to the breach.
Yes.
And making sure the damage wasn't too remote or unforeseeable.
4 legs of the table.
Exactly. Pay extra attention to negligent misstatement. That's a big one for us. Know the common defenses. Contributory negligence, illegality, assumption of risk.
Don't forget them.
And most importantly, really internalize your duties and the high standard of care expected under the CEPCC. This isn't just theory, it's your daily practice guide.
Well said. And maybe a final thought to mull over. Think about every interaction you'll have as an agent, every piece of advice, every property detail you share.
Yeah.
How does this concept of duty of care influence those actions? Understanding this isn't just about avoiding trouble, it's genuinely about building trust and reputation. Those are your most valuable assets, really.
Absolutely. Building trust. That's the name of the game. So you've bravely taken this deep dive into the sometimes tricky world of negligence with us today on Ace Your RES exam.
Hope it's helpful.
We sincerely trust this session has given you a solid, practical understanding for your RES exam prep. We extend our very, very best wishes for absolute success in your upcoming exam. Go out there and ace it.